Good morning. Are you Charles Darling? And Mr. Darling, in cause number 24, DCCR 1384, you're charged with the third-degree felony offense of stalking from April 11th of 2024. And what that means is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 10 years in prison. Do you understand? And I have here on the tablet a plea bargain rejection that has your signature on it with that of Mr. Lewis's that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to plead to a reduced charge of a Class A misdemeanor of harassment for a 1-year deferred adjudicated probation. You have every right to reject that and have your case set for trial. I want to make sure you understand what the possible consequences are and what your options are, and do you understand all of that? And do you want to reject that offer and have your case set for trial? I'll do that. I do want to make sure you understand, Mr. Darling, that after today, I will not accept this plea agreement. Obviously, if you didn't do it, you didn't do it, but this is quite a reduction and a good deal if you did. But I'm not going to accept a misdemeanor reduction after today. Once your case is set on the trial docket, it is going to go to trial, or it would be a plea to something different. Do you understand? All right, so we'll get it set on the trial docket, and you're appointed. Mr. Darling, Mr. Lewis has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him, and I can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? All right, so Mr. Lewis, you'll remain on. He will begin preparation for trial. Make sure you stay in touch with him. He'll let you know when you need to be back.
Right. Man, just so the record is clear, I don't have any indication that there's been any issues between the complainant and the defendant. We just admonish him again as to the no contact. I will also reach out to her again. We've had several conversations, let her know kind of what juncture we are, what she wants to do, and I'll let the court know something well in advance of the pre-trial.
Okay, thanks. So I want to make sure you understand, Mr. Darling, it's a condition of your bond that you have no contact or communication with Quandisha Celestine. You understand? Okay, so that means you're not to be in contact with her personally, but also you're not supposed to send messages. Don't send anything on social media, text messages, anything like that. Do you understand? If I find out, she can't give you permission to do that. So she can't say, no, it's okay, it's fine with me, come on over, or let's do whatever. She can't give you permission to violate my court order. If you violate that court order, then your bond will be raised, and then you'll be back in jail waiting on trial. Do you understand? Okay.
And I will let her know this may be what he wants to address, that goes for her as well, Judge. I think there has been some communication directed at him. I don't want him to accidentally violate because she's doing that.
Well, I can't tell her what to do because she doesn't have a case pending in front of me. I can only tell you what to do. So Ms. Malfino is going to talk to her, but if she contacts you, your response is, I can't talk to you. Don't respond. Let her know that up front. She's going to let her know that. No more communication, no contact until this case is over. Understand? Okay. All right, you're free to go.
All right, thank you, Jim.
And then Anthony Vidal. Say, good morning, sir. Are you Anthony Vidal?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He does, Judge. Judge, you may recall on this case, we discussed maybe a restitution deal. He's in a group home, and after meeting with his team, we ended up agreeing to do a 1-year deferred to a Class A misdemeanor. If we didn't write it up right, that's on. I didn't catch it. And pay that full restitution over time.
Okay. So it's a
Class A criminal mischief.
all right. And will he waive the formal reading of the indictment?
He does, Judge.
Mr. Vidal, in cause number 24 DCCR 2062, the state is elected to proceed on the lesser included offense of a Class A misdemeanor criminal mischief from July 26th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily, and because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for 1 year deferred adjudicated probation. There would not be a fine, but there would be restitution in the amount of $3,025. Is that your understanding? And are you a U.S. citizen?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Bless you. Is there any evidence that Mr. Vidal is not competent?
No judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 1 year.
Yes, ma'am.
You're ordered to pay restitution in the amount of $3,025 and to follow all of the other rules and conditions of probation.
Yes, ma'am.
If you do all of that, this is a great opportunity because you don't have a conviction on your record. And at the end of the probation period, if you're successful, the case is dismissed. The other side of that, though, is if you violate any condition of probation, you can be brought back into court and you could be found guilty and sent to the Jefferson County Jail for up to 1 year. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. You just need to have a seat here in the courtroom. Probation's going to call you up to her desk when she's ready to go over all of your paperwork, and she's at that desk right there, so just watch for her to call for you, okay? All right, good luck to you, sir. Thank you.
Thank you, Your Honor.
No fine.
No fine. Mr. Wilkerson on Charles Young.
Morning again.
Good morning, hun. Give me just a second. All right, you're Charles Young. And Mr. Young, in cause number 25 DCCR 0102, you're charged with the second-degree felony offense of burglary of a habitation, and that is from November 4th of 2024. Let me check something real quick. And what that means is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand? And I have here on the computer a plea bargain rejection that you've signed with Mr. Wilkerson that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for a 5-year deferred probation. You have every right to reject that and have your case go to trial. I just want to make sure that you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get that done. I do want to make sure you understand, Mr. Young, that after today, once your case is on the trial docket, I don't accept this agreement again unless some new evidence that comes up that your attorney or the district attorney doesn't know about. Do you understand all of that?
Yes, ma'am.
All right, we'll get it set on the trial docket. Mr. Wilkerson will begin preparation. You're free to go. Thank you.
Thank you, Your Honor. Excuse.
Yes, sir.
How are you, Mr. Coleman? That's just how I want you to be.
All right, sir, you're near Benware?
Yes.
And Mr. Benor's case is set for trial to begin with jury selection next week. Mr. Gertz has filed a motion for continuance, has a specially set case in Judge Arkeen's court in Orange with a protection order. I have contacted her this morning to kind of double check the status of that, and she's assured me that case, which is also a retrial, But it is a case that involves a child and I believe someone in custody, which, or
He's
not in custody, but it is
it's
a child.
continuous as of right now.
And so because it has a child victim, that will take precedence over ours. And so what I'm going to do, Mr. Gertz, I was just mentioning to Mr. Coleman, based on the nature of this case and the issues that are involved that could be potentially different with witnesses coming up in the next trial, I am going to set this somewhat specially. I will probably have a protection order done as well as soon as it's set so that this case can get tried before the end of the year. If there is any possibility of not being here, any type of vacations, I need to know about them this week. Make sure that Ms. Holmes has those because once it's set, it will be expected to go. All right. Mr. Benware, stay in touch with Mr. Gertz. He'll let you know when you need to be back and ready for trial. You're free to go, sir.
Thank you, Judge.
And then Christopher Thomas, Mr. Gertz, 24 DCCR 1378.
Judge,
Just one second.
Sure, I'll hold it.
and we can talk about it with you.
All right, let's talk about that. Judge Raquel West presided over a morning docket that showcased her usual steady hand equal parts patient, firm, and clear in laying out what's at stake. The first matter involved Charles Darling facing a serious felony stalking charge. The judge walked him through the plea bargain on the table, making sure he understood the offer to reduce it to a misdemeanor harassment with a year of deferred probation. She was crystal clear. This was his one shot at that deal, and once it moved to the trial docket, there would be no going back. I thought she handled that exchange well, no pressure, just facts. The defendant came across quiet and agreeable, not argumentative, though you could sense he was weighing the risk of trial against the finality of accepting a deal. When bond conditions came up, the no-contact order was emphasized repeatedly. Judge West did not leave wiggle room. She even addressed the possibility that the alleged victim might reach out first, making it clear that it would still be on him to shut down contact immediately. That's good judicial housekeeping, closing the door on, but she said it was okay. Excuses before they happen. His attorney, Mr. Lewis, seemed steady, though not particularly vocal, and the brief mention that the complaining witness had also initiated some contact-raised eyebrows. Still, Judge West kept it even-handed. She can only control the defendant's conduct, not hers, and she made that distinction plain. Then came Anthony Vidal's case, which played out with much less tension. Here, both sides had already reached an agreement, reducing his matter to a misdemeanor with restitution. The restitution number, over $3,000, wasn't small, but the benefit for him was clear: a shot at probation without a conviction on his record if he complied. Judge West went through her checklist thoroughly: competency, understanding of rights, voluntariness of the plea. Vidal was polite, answered clearly, and seemed to know exactly what he was agreeing to. His attorney had the paperwork lined up, and the judge followed the agreement without hesitation. What stood out was her effort to explain not just the consequences of failure, but also the upside, a true second chance if he makes it through probation successfully. It was a firm but encouraging moment that really captured her balance of accountability. An opportunity Charles Young's hearing returned to the harder choices defendants face. Charged with burglary, he had the option of a 5-year deferred probation on the table, but he rejected it. The judge again took the time to ensure he understood this was the last chance for that specific deal, and that once the case went to trial, it was either full trial risk or something entirely new if unforeseen evidence came up. Young's demeanor was straightforward: yes ma'am, no fuss, no hedging. He wanted his trial, and Judge West respected that choice without commentary. His attorney, Mr. Wilkerson, looked prepared to move forward, and the whole exchange was short but thorough. It reflected the judge's efficiency, no wasted words, just a fair record that the defendant knowingly made his decision. Finally, there was a scheduling wrinkle in Benware's case. His attorney had a conflict with another trial involving a child. which understandably takes priority. Judge West navigated that with flexibility, noting she'd set it specially to make sure it didn't fall through the cracks. Again, it's the kind of calm, managerial side of courtroom where most people never see hurting cases and calendars, so justice actually gets done. Overall, the courtroom atmosphere was calm, procedural, and professional. The only real tension came in the first case with the bond conditions, but even there, the judge's firm reminders kept it grounded. No dramatic blow-ups, no chaos, just the steady march of cases being handled. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone,